You are welcome to the Lord TV, your number one fantastic reality TV that gives you all that it takes to be enlightened on trending news such as politics, entertainment, sports, and what have you. If you are new on this channel, kindly click on the subscribe button as well as already subscribed. So please don't forget to drop your comments anytime I drop new videos. Thank you. Ciao, ciao.
Viewers, today's headline reads: Eminent leaders drag Supreme Court to UN for rejecting the review of its judgment on the 2019 governorship election in Imo State. But before I proceed, don't forget to click on the red subscribe buttons as well as the bell button to get updated anytime we upload new videos. The news and details. A group of eminent leaders of thought under the auspices of the Third Force movement in Nigeria have faulted the Supreme Court for its decision to reject the review of its controversial judgment on the 2019 governorship election in Imo State, which has cast serious doubt over the integrity and sanctity of the Nigerian judiciary. The coalition of leaders of conscience in the country, in a statement issued on Tuesday and signed by their spokesperson, Dr. Olusegun Obe, said the latest ruling of the Supreme Court, which rejected the application for the review of its earlier judgment, runs contrary to the precedents set by the Supreme Court on the matters of review, thereby violating the spirit and principle of justice, which is the whole essence of the necessary for the judiciary, and so many hitting the political tension in Imo State and the Southeast at large. The group, however, said it is now set to internationalize the matter by immediately sending a formidable petition to the United Nations, United States, United Kingdom, African Union, European Union, among other world powers, in pursuing the cause of justice on the controversial judgment and subsequently ruling of the Nigerian Supreme Court, which we regard as a ruthless attempt to sweep fraud and injustice under the carpet. It added, "We are therefore resolved more than before to be steadfast and resolute as concerned leaders of conscience in Nigeria to pursue this cause of justice to its logical end over these worrisome precedents by the Supreme Court, which has since fostered a dark cloud over the survival of Nigerian democracy and the peace and stability of the Southeast. Accordingly, we plan to further engage and rally national leaders of conscience like Nobel laureate Professor Wole Soyinka, Professor Ben Nwabueze, San, Chief Emeka Anyaoku, Alhaji Balarabe Musa, Admiral Ndubisi Kanu, Chief Ayo Adebanjo, Bishop Matthew Kuka, Dr. Kalu Idika Kalu, Solomon Asemota San, Professor Pat Utomi, Dr. Olisa Agbakoba San, Mr. Femi Falano San, Comrade Shehu Sani, Chief Mike Ozekome San, Dr. Obi Ezekwesili, former president and heads of states, the leadership of the Nigerian Bar Association (NBA) and the international community, among others, to help monitor development concerning this historical matter. It will be recalled that the body had previously averred that apart from the fact that the total valid votes which the Supreme Court based its ruling on erroneously exceeded the total accredited voters by the Independent National Electoral Commission in the election, Senator Hope Uzodinma may also not have fulfilled the constitutional requirement for a validly elected governor of having to score at least 1/4 of all the votes cast in each of at least 2/3 of all the local government area in the state. The leaders also asserted that the judgment completely overthrew all known judicial precedents and electoral jurisprudence in Nigeria, and would appear to be based on extrajudicial consideration, and therefore require a desired reversal by the Supreme Court to prevent the precipitation of a major uprising and anarchy in Imo State capable of overwhelming security and stability in the entire Southeast. The group, in an earlier statement, had quoted late Justice Chukwudifu Oputa as regards the powers of Supreme Court to review or reverse its earlier decision. It said while delivering the lead judgment in Adegoke Motors Limited, Adesanya, 1989, 13 NWLR 250 at page 275A, Justice Oputa, also known as the Socrates of the Supreme Court, considered the powers of the Supreme Court as the final court in the land to review its earlier decision and said inter alia, "We are final not because we are infallible. Rather, we are infallible because we are final. Justices of this court are human beings capable of hearing. It will certainly be short-sighted arrogance not to accept this obvious truth. It is also true that this court can do inexhaustible good through its wise decision. Similarly, the court can do incalculable harm through its mistakes. When therefore it appears to land counsel that any decision of this court has been given per incuriam, such counsel should have the boldness and courage to ask that such a decision be overruled. This court has the power to overrule itself and has done so in the past, for it gladly accepts that it is far better to admit an error than to persevere in error." The Eminent leader group then said, "We also make bold to state that the application before the Supreme Court is not an appeal but a review, which the Supreme Court in previous instances have claimed jurisdiction over, so as to correct errors of misinterpretation or fraud in judgment previously given in error. So, we wish to remind their lordship of Orika Jev and Oz v. Oyetom and Oz, 2015, 484, where the Supreme Court had in an earlier ruling mistakenly ordered that INEC conduct rerun election, but upon application for review, the court discovered it gave the said order based on a wrong interpretation of Section 133(2) in conjunction with Section 141 of the Electoral Act 2010 as amended, and subsequently set aside the earlier ruling and ordered INEC to issue the applicant a certificate of return. Furthermore, there is also a precedent of review in the case of Olorunfemi v. Asho, 2000, 143. The Supreme Court, in its 18th March 1999 ruling, set aside its earlier judgment delivered on the 8th January 1999 and ordered that the appeal be heard de novo by another panel on the ground that it ought to have considered the respondent's cross appeal first before allowing the appellant's appeal. These are examples of where the Supreme Court has previously set aside its earlier rulings, which are not by reasons, typographical or errors, but misinterpretation and administration of justice by error, as evidenced in the Imo ruling, which gave mandate to Uzodinma, who was never a candidate of any political party with votes, not in tandem with total accredited voters. Therefore, the constitutional finality of the judgment of the Supreme Court, where it flows from or rests on fraud and misleading evidences, can never serve the purpose of justice, for the Constitution created the Supreme Court and therefore defeats the whole essence of the judiciary, so should be corrected for prudence and posterity's sake. Thank you for listening to this news. Viewers, you can see how this issue is being taken to the international level. Issues that's supposed to have been resolved here peacefully, but because of lack of understanding, it is now being internationalized. The word they say is enough for the wise. Now that it has been internationalized, we will now see the interference, the level of interference that Nigeria will receive concerning this matter. I have nothing much to say than to wait for the international contribution. But then I believe that no matter what, the issue will definitely have a resolve. So what is your own comment concerning this news? Don't forget to leave them behind. Click on the subscription buttons as well as bell buttons to get updated anytime we upload new videos. Thank you.